Good morning, Roger. Can you hear us, Roger?
Yes, I can, thank you.
Thank
Very
you.
much. Good morning, Tom.
Morning, Roger. How are you?
Good, good. Finally got that trial underway.
Yeah, that's right. You've been trying for a while. Roger, while we're here,
Yes, Tom.
I'm just wondering if you've had any further thoughts on timings.
Sure.
I mean, I'd seen your message that you didn't think you'd need as much time. My
Well,
but
okay.
No,
The
I
way
just
I
was
see it,
interested.
I assume that you'll be with the defendant most of the day. Would that
Yeah.
be correct?
Yeah.
Okay. But Mr. Abdelazim Osama, okay, he's quite flexible. All right,
Okay.
so he's available today or tomorrow, and so if it finishes early, actually, I was just about to go and see the defendant. He's here, but he's in a different room. I was just about to go and ask him how long it would take to get Mr. Osama here if you indicated that you were finishing in the next hour or so. I take it that's a low probability that you'd be finished today, correct?
I think so.
Yeah. But if so, I think within an hour or so we could have him here. I'll just get somebody to check that.
Fine.
And then Mr. Raghavanshi, he's pretty keen to have it at a fixed time slot if he can, and that would have told him 11 a.m. tomorrow.
Okay.
I've sent him a link, and he'll do it from his office.
Okay.
So we can fit Mr. Osama around him.
Yeah. All right. Well, I mean, it's not impossible. I don't know. It depends, but it's not impossible
One never
that the defendant's evidence will go overnight. I mean, I don't mind slotting in Mr. Raghavanshi at 11 a.m. and then coming back to the defendant if the judge is happy to do it.
Yeah. Okay. Fine. I don't think Mr. Raghavanshi is going to suffer if it's.
I see.
If he doesn't get his way.
Okay. Fine. I mean, I think that I'll be quite short with Mr. Abdelazim.
Yeah, an hour or so.
If that.
Yeah.
So yeah. I'm fairly confident that I'll get through it before, well, Dubai lunchtime tomorrow.
Sure.
I mean, what's your thinking on my witnesses? And
well,
do you require?
I think we'll definitely be interposing your witness. I think I should start with the substantial witnesses. So that would mean that I start with Mr. Jaberi. No, sorry. Jabera. Sorry, I've got a Jaberi in a different case.
Sure.
With Mr. Jabera tomorrow at after you. So if you finish by lunchtime, that would be 1, would it? What time is lunch anyway these days?
1 till 2, and then say
1.
2 o'clock.
Yeah.
Start with
so
him.
So I go for 2 hours with him. I'm pretty sure I'm unlikely to finish, but then we can simply interpose William Beckley. And if we don't finish William Beckley by, say, 7, asking the judge perhaps to sit a little late, well, we'd have to finish him off at 4 o'clock on Wednesday, I guess. But one would hope that won't happen.
Right. Okay.
Makes sense?
Yeah. I hadn't quite realised that we'd be chopping and changing between witnesses quite that much. I'd taken it from your email to my solicitors that you didn't think you would need all of the time that you'd been allotted, but there we are. Okay. Well,
no. What I mean was, what I was referring to was the what's now an M3, okay, which will definitely have sped things up, because that was going to be long and slow, and it now won't be. So
fine.
A lot of what would have otherwise been sort of a procession of from one document to another document to another document.
Fine. I don't think we've ever had an indication. Are you going to be cross-examining Mr. Mohammed Anjum?
The
document production statement.
Document production. No, I didn't think so. No.
So you're not. You don't need him. Okay, fine. No. That's for sure.
No, it's not for sure, unless it comes up. At this stage, I had indicated that I didn't think he knew much about it, so wasn't not much point in. But
I know
if some particular
I mean,
question comes up,
he's got a job. I think you need to make a choice. Do you want to have a think about it and let me know at lunch?
Yeah, I'll have a think about it, but it
all right.
didn't seem a priority.
All right, fine.
Okay.
Good. Okay, and we've got plenty of overrun time, and day 3, if we run out of time with evidence, and if we go much faster, then we can do oral submissions.
Yeah.
Good.
The
All right.
judge did indicate that he wanted us to crack on with it, so
yeah.
Easier said than done.
Yeah. Well, thanks. Okay, that's helpful.
Okay, brilliant. Well, if
Morning.
I'm happy if you explain.
We're here and logged in, and we'll be remaining silent and off video, of course, throughout. But just in case there's any need, should the judge wish for us to say anything or prove that we're here, then we're happy to. Thanks, David. No worries.
I've got Mr. Omar Ramadan. He's assisting me in the same capacity.
It's a public trial.
Just coming back to that, Tom, the problem, whilst I do believe I will take less time cross-examining than I indicated, I think the problem is that the first witness you start with is going to take the longest, because there's a lot of overlap between the evidence of those two witnesses. So it hopefully won't be necessary to cross-examine everyone twice about everything. That's my thinking. But the first one, unfortunately, will take longer. And so if we start with one, it's going to have to be in position, interpose.
Yeah. All right. Well, I mean, you'll deal with it whichever way you
Yeah.
I mean, obviously,
that's just the way I see it. I just don't believe that you can.
Yeah.
Do it any other way.
Having two witnesses breaking halfway through is probably less than ideal. So if we can, I mean, I'm sure you'll do your best.
Exactly. I'll try.
Okay, you might want to raise that just with the judge briefly. I mean, it's up to you.
I was going to suggest that you just record what we've discussed, and then I'll chime in with anything that might be missed.
I'll probably do that at the end of my opening.
Oh, okay, sure. So we'll crack straight into the openings, right?
I think let's get going. Yeah.
Okay, sure.
Unless he's got. I mean, it's your case. So unless he's got anything.
Sorry to keep you all waiting. We are just waiting for the judge to join. Yeah, thank you.
Thanks.
Good morning, everyone. Can you hear me?
Good morning, Your Honour. Yes, I can hear you.
Good morning, sir. I can hear you too.
Good morning, Judge. This is Reem
I've got,
speaking.
either counsel at the moment. I have the pleasure of seeing them, but I can't hear them.
Oh,
Can you hear us now?
Reem, can you hear me?
Hi, Judge. Yes, I can hear you. Can you hear me? Sir Richard, can you hear me?
Just about. Wait a moment. It's something on my computer. How's that?
How about now? Can you hear us now?
Yes, yes. Thank you very much, Mr. Montague-Smith. Good morning, Mr. Bowden. I can see you. Thank you.
good morning, sir.
I'm sorry for the slight delay in getting started, but it looks as if we're ready now. Reem, can you hear me?
Yes, Judge, I can hear you. Can you hear me?
I can hear you very well. Now,
Thank you.
I imagine you want to recite the usual form of words to get us formally underway.
Yes, please may I begin?
Yes,
If that's
please.
okay. Thank you. Hello, Judge. I would like to begin by reading out a statement. This trial is in the matter CFI 029-2018 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Adil Shah Goddard, Middle East LLP. Lead counsel is Tom Montague Smith, QC. The defendant is represented by Ahmed bin Dahi, advocates and legal consultants. Lead counsel is Roger Bowden.
Well, to the extent that you need confirmation from me as to the basis of this hearing, I hereby give it to you.
Thank you, Judge.
I just need a moment to plug something else in. Sorry about that. I've got I was proposing to have the e-bundle on a separate screen. I just need a moment. Ah, right. Good, we're all there. Yes. Well, now let's get underway. I've got your proposed timetable, and as far as possible, we'll stick with that. So let's hear an opening.
That would be me, sir. Good morning.
Yes.
Well, counsel's name is Bowden, and I appear for the defendant, but also the counterclaim claimant. And it has been directed that we go first
Yes.
because of the way that everything has ended up, sir. I'm going to skip through the facts pretty quickly and spend most of my opening, sir, on what I believe is the key evidence. And so I won't be going into the claims because they've been rehearsed, I think, many, many times, and I hopefully well understood. And if they're not, sir, we can certainly come back to them.
Well, can I put a marker down right now,
Yes, sir.
Mr. Bowden? I'm going to need some assistance as to the legal basis for the claims in malicious prosecution and abuse of process. And I'll need to hear from you how under the court law and the other relevant legislation going to the establishment and operation of this court, these causes of action, which are causes of action in English law, are actionable in DIFC law. And the other thing I'd particularly like a little help on, as well as what you're proposing to cover in your opening, is a look at the is a look at the documents. I'd like to see, if possible, some of the documentation that demonstrates that within the accounts of TIG, there was material which would have informed, on your case, the claimant, would have informed the claimant of the entitlement of your client to be reimbursed the sums which he had been paid, and to receive reimbursement in respect of the 610,000 and the like. And a brief look at the report that was available just when we came to the application to set aside the judgment in default. I'd like to see be introduced to that, albeit briefly.
Yes, well, thank you, sir. Dealing with the first point you raised first, I had been waiting, sir, to see what my learned friend said in his opening skeleton in relation to that challenge, which had been flagged but not developed. And it may be, sir, that I'm still trying to understand what was said, and I was intending, sir, to return to that subject in detail in the closing submissions, and I trust that that will be acceptable, sir, rather than dealing with it in the opening.
Well, it's not. It isn't really acceptable. I've got to have at least some skeleton framework of what
Yes,
your case
yes.
is as to the foundation of these two claims of malicious prosecution and abuse of process, so far as DIFC law is concerned.
Well, the simple answer to that, sir, is that this is a common law court. It is a these are common law causes of action, and the DIFC laws, sir, and particularly the laws of obligation, sir, do not exclude the other torts. So there's no they are inclusive, sir. So it's an unusual situation in the DIFC that some of the law of the DIFC has been codified, but a great deal has not. And this is one that has not, sir. So that's the straightforward answer, sir. Is that the DIFC law certainly doesn't.
Where it fits into Article 8, the Cascade section, if you remember.
Yes, I do remember the Cascade sections here.
Well, just give me a sentence or two as to how you plot your course through Article 8.
It would fit in under the fifth limb, sir, or the second, actually the second limb, any other law to which is appropriate, other than DIFC law, and indeed to the law of England and Wales, which it's firmly based upon.
I see. Right.
I mean, I was definitely planning to come back in detail on it, sir, and I confess I haven't fully completed my submissions on that, but I will. And the answer is exactly that, sir, that the DIFC law certainly doesn't exclude it. It would be a somewhat extraordinary proposition if it did, sir.
Well, there is a line of authority that is to this effect, that in matters of procedure,
yes,
common law rules can be relied upon because they are not precluded by Article 8. But otherwise, one is in the grip of Article 8.
Yes. Well, even if that were so, sir, well, firstly, the law would have to deliberately exclude these very well-established torts of great antiquity, which have been around for at least 400 years, sir. And there's nothing that I'm aware of in any case, any reading, or any authoritative texts which says that those torts are excluded. And really, sir, that cannot be. That's a simple proposition. And secondly, sir, under Article 8, under the waterfall provisions or the cascade provision, it fits into, just from memory, sir, 2 and 5.
Well, the law of England and Wales is the last stop
Yes,
on
yes,
the road to Calvary.
exactly, sir.
And you say we
The
get there.
catch-all. The catch-all, sir.
Right. All right.
Well, because of course this tort's alive and well in US law, sir. It's alive and well in New Zealand law, sir. Australian law, every law, every provision of every common law, sir, preserves these torts. Extraordinary proposition if it wasn't. But one I'm very happy to deal with, sir, and will be of a very interesting academic.
Fine. Well, now you take your own course in opening.
Thank
We
you,
need
sir.
to stick fairly rigidly to our timetable,
Yes.
but just bear in mind my request that I would like you to take me to some of the documents that on your case would demonstrates that the claimant would have known perfectly well that there was a justification
Yes, sir.
for these sums.
Yes,
right, on you go.
And when indeed, sir, when I said that I was going to spend most of my opening on some of the detailed evidence, that is precisely what I was talking about.
Good.
So
very good. Okay.
I'd hesitate to say great minds think alike, sir, but
Yeah,
I agree, sir. This is the absolute key to this case, and it does turn on a relatively few documents which sit right at the centre.
Very well. Then on you go.
And on we go, sir. So, and there's no need to go there, sir, but the first witness statement of the claimant, Abdelazim El Shikh El Fadil Hamid, and Mr. El Fadil, I think is the correct.
We can refer. We can call him that, can we?
Yes, Mr. El Fadil.
Without any discourtesy, Mr. El Fadil. Yes.
Yeah. He or indeed Mr. Abdelazim, because he.
Yep.
As he's commonly known. Right. So at AE7, which is the seventh witness statement.
Yes, this is the long one.
That's E1, sir, in the bundle, but we don't need to go there, sir. He started working for Banawi Industrial Group, which known as BIG, and on the 1st of November 1999. So, and then he originally worked in Egypt, sir, for Ashwa Technologies, a subsidiary. In 2007, he was promoted to the financial controller of the group. Then he went to corporate treasurer, director of finance of BIG, BIG, sir, Banawi Industrial Group. In 2007, sir, in 2007 he was promoted, and he held that position right through until 2013, sir, when he started an employment contract in the DIFC. And you'll know there is a tension in the evidence there, sir, as to whether he did resign his employment in Saudi to move to the DIFC, but whether that is a break in his employment for the purposes of his gratuity and indeed his holiday pay is a moot point.
Yes.
He, from that time on, sir, from April 2015 until February 2018, he was the Senior Vice President of Finance and Planning. So he sat second on the corporate tree, sir. He was behind the Chairman and CEO, Mr. Banawi.
Yes.
So, as he said in his evidence, sir, he's very close to the chairman and his family, and became very involved in his personal and business affairs. There's a suggestion in the evidence that he might have been in a position to spill secrets after leaving the group, but it's notable, sir, that he never has, not then and not now, sir. He is indeed a person who's a model of discretion. Where things went wrong, sir, and this is at paragraphs 22 to 27 of his first witness statement, was the creation of a list.
Yeah, go on.
It was the creation of a list, sir, which set out a number of payments, and that's to be found at H7, that document, sir.
Yes.
It might be worth having a look at it as we go, because this is really.
Well, I'm just to help me through looking at the e-bundle.
Yes, sir.
There's a heading there's a box file number 24 documents.
Yeah.
Is it in there?
No, sir, it's under section H.
H. Okay.
So it's up.
Right.
Your Honour, are you on the case lines? Because what I could ask my solicitors to present the documents as they're referred to, if that would assist.
No, I don't know whether I'm on case lines or not. What I've done is I've gone into the CMS and in other words, through the case management electronic system. And I have the e-bundle, which H. Well, I'm going to click on H. Mr. Bowden just mentioned H. Okay, now, Mr. Bowden, within H, what am I looking at?
If you go to the top right, sir, there should be some numbers in red, we'll call it, and it should be say H81 at the top right hand side of the page. It might be helpful, sir, if you are on case lines. That's the one across the top of the page. It should say home, find, view, present,
That's
notes.
right. Yeah, forgot all that.
Okay, great.
Yeah.
Okay. And even if we go to find, sir, if you go to pay, and then over the right hand side of that banner, find page.
Find page, yeah.
Click on that, and if you type in H81, no dashes required this time.
H81. Yes, I'm there.
And that should,
yes.
Indeed, sir, if you then move to view and you rotate right, across the banner, go to view, rotate right. Maybe I wasn't planning to present many documents, but I might.
No. Yes,
and then there, sir, we see something in yellow, which actually says administrative expenses.
Yes.
Now, what this document, this spreadsheet is, sir, this was as at the 18th to the 21st of January. This was the entire indebtedness of the industrial group, sir.
Yes.
And in that group, and in the spreadsheet, Mr. El Fadil had, because he had ultimate responsibility for the preparation of this document. He doesn't shy from that. He had put in there, sir, and it's down at 16 under administrative expenses.
Yes, I can see. Yes.
Right. He put in 610,000 dirhams payable to him. Various payments for Villa Rotana, Swiss, and Villa Rent Dubai. Okay. Yeah. This is what kicked off all of the problems. And there was a meeting.
Yes.
On the 22nd of January, 2018. Okay. And at which this matter was discussed, this very line entry that we're looking at there. The chairman brought it up and said, I didn't know that was so much. What's all that about? To which the defendant replied, yes, he gave a brief explanation that this is the payments I have made on your behalf regarding the villa in Switzerland, the villa in Germany, the villa in Dubai, and indeed, as we'll see, various telephone messages, telephone bills which were unpaid, some rent which was unpaid, rent for his daughter, telephone accounts for his wife and his sons and everybody else. And there was a brief discussion over that, sir. Now, this spreadsheet that we're looking at here, sir, was brought about by a change in policy in the group in late to mid 2007, where it was said, we're going to list all of the payments which are due, and then we are going to prioritize them. Okay.
Yeah.
And it wasn't.
Well, I've read all that. I understand that.
Yeah.
And they have, in fact, they've got to keep a wary eye on a monthly basis of the state of the bank accounts of the claimant.
Precisely.
And then prioritize accordingly.
Yeah, and it was those priorities, sir, that caused the defendant to leave his employment, because in paragraph 24 of his witness statement, he says, the new procedure provided that the list should always give priority to payments related to the chairman's lifestyle in Dubai, Europe, and his private jet. This procedure significantly increased the financial pressure on the claimant, as not always cash available to meet the expenses of the chairman, and priority to the business expenses of the claimant. And so this is why he was putting his hand in his pocket, sir, because there was this enormous tension between paying suppliers, paying wages, paying everything else, and paying primarily, sir, for this jet. So through the late 2007, early 2018, he tried different roles, but the people who came into the role, they couldn't deal with it either. And so by January 2018, sir, he had said, I am leaving and I will be leaving in May. And this, sir, caused all the difficulties. Now, moving down, sir, you will have seen in the skeleton argument that over the years, and we're talking from 2012, Mr. El Fadil, and this is undisputed, sir, had paid the princely sum, sir, of 7.289518 million. So 7.3 million dirhams he had paid out of his own pocket, sir, on behalf of principally the chairman, but sometimes also the company and his family. It's said, sir, 72% of these payments were absolutely fine. Now said that they were absolutely fine. 28%, sir, it was said that he had stolen. And that allegation's later been wound back to, well, you paid yourself without authority. And that is what lies at the very heart of this case, sir. Excuse me. So, before we move on from this document, sir, what the claimant's case is this, is that the placement of the 610 in this list was entirely correct. The whole reason for the list was to have all of the debt consolidated in one place, and this was a debt, so it was there in the right place. He wasn't paying himself. It was put forward for approval to be paid. If it got it, well and good. If it didn't, well, that was what happened. And as it turned out, it didn't get approval until 2020, sir, when Your Honour's judgment of 3rd of March 2020. So, just coming back to moving through the evidence quickly, sir, on the 22nd of January, there was a discussion over this matter. The chairman said, well, I didn't know it was so big. I mean, we're all often surprised at the state of our personal finances, sir, and maybe that was what it was about. On the 24th, there was a meeting in Jeddah. The defendant was at that meeting. The internal auditor was at that meeting. I believe Mr. Jabira was at that meeting, and the chairman was at that meeting. And at that meeting, sir, it was agreed to do an internal audit. And the defendant, he said, yes, fine, let's do an internal audit. I'm very happy with that. That was at the end of the week, over the weekend, sir. He went back flew back to Dubai. When he got to Dubai, sir, he went into the finance department and he went to the files, and we'll look at those in a moment, sir. And he gathered up all of the documents, which finally found its way into that EMA Saxena report that we'll also look at shortly, sir. That's what he did. Whilst he was doing so, sir, he saw Mr. Taj, the internal auditor, doing the same thing. I mean, the files were on the shelf, so they were standing shoulder to shoulder, shuffling through the papers, getting them, sir. So he thought that everything was fine. There's another meeting, sir, and this is dealt with in his witness statement in paragraph 36, which started with others but ended with just himself and the chairman. And that was on the 3rd of February, sir, 7th witness statement at paragraph 36. The chairman then asked him, wait for a year before you resign. It's pretty obvious, sir, that Mr. El Fadil was, key employee, and he was responsible for running the entire organisation, and he'd been there for 20 years. He was very valuable. So, but he told the chairman at that meeting, his evidence is anyway, that no, I'm not resigning. I'm sorry, I'm not staying. I am resigning, and I will be going in May. It is consistent. I know that account is disputed, and of course we don't have the chairman's evidence, but what is consistent with that evidence is that the very next day he got promoted, sir. And that comes down to, we're just going down 2 documents. So we were at H7. If we could quickly flick, sir, to H9. Yeah. Left-hand panel.
Yeah.
Go down 2.
Yeah, I'm there.
Right. And we see there, it says, first, in recognition of Abdelazim El Fadil, Vice President, Finance and Planning, long-standing loyalty, service and dedication to the group and to the chairman and CEO and leading the day-to-day finance function over the past years, he will take on the newly created position, right? And that was said, sir, to be a promotion. Now, you've seen the evidence here of Mr. Beckley and Mr. Jabera, that everyone was surprised and shocked. Shocked was indeed the word that Mr. Beckley uses to see this evidence, and that it immediately caused concern. Well, this is in marked contradistinction to that, sir. So what did happen, though, sir, is that he didn't stay. He did indicate that he was still going to leave, and that is when things turned very dark. So that was in February, sir. Nothing much happened in March. There doesn't seem to be any evidence in March, and indeed for the first 3 weeks of April. Although what did happen on the 2nd of April is that the group employed Ernst & Young, EY, sir, to start an audit of various matters. Now, it's highly significant, sir, and it will be dealt with in the evidence, that they instructed Ernst & Young not to speak to the defendant. So if there were things that they didn't learn, sir, that they could have learned, that's probably the reason why. Anyway, sir, moving on, in April, on the 18th of April, a witness, 19th of April, sorry, sir, Mr. Jabera swore a witness statement, signed a witness statement in this court, sir.
Yeah, well, then we have the ex parte application.
Then we have the
for a passport order,
yep,
and so on.
Exactly, sir.
Yes.
Moving on from that, they in early May, sir, they filed proceedings seeking 1.3 million, which they subsequently got under the default judgment, sir. I think we're well aware of that. Then, sir, they actually sought a further 1.4 million, and at the same time in May, sir, they went to the Dubai police and accused him of the theft of the 2.7. That's a 1.3 plus a 1.4.
Yeah. I'm so sorry to interrupt you again, but
yes,
I'm pretty familiar with the chronology. Why don't we go to the Saxena report, which came before the court, but without background documentation on the day that your client moved to set aside the default judgment?
Yes. Okay. And the exact point, sir, that you will have noticed in the PTR, sir, I made an application about box file number 24.
Yeah.
And that was because we have said that it is in file 24 that this evidence resided. And so our case has always been that the claimant knew at all times that this information was available. I mean, that is how the 610,000 got into that list that we were looking at earlier, because they had the documentation and they signed it off. So, sir, there's been a lot of toing and froing about box file 24. There's no point in going to look at the J box file 24, sir, because there's nothing of value in it. Those were, I described them, sir, as a few scattered documents from December 2017. That wasn't quite accurate, sir. It was a few scattered documents from 2017 and some more scattered documents from 2016, but nothing relating to this case. But if we go down, sir, to M, journal entries,
yes.
And then we click on M3, the photographs, sir.
Wait a moment. Journal entries and related documents.
Yes, exactly.
Yeah. Yes, I'm there.
Right. Now it could as well be, my learned, the claimant, sir, has declined to call that box file 24, but it is file 20, at least file 24.
Yeah.
Now we're looking at some photographs.
I'm sorry. I'm listening to a lot of factual assertions from my own friend, lots of which are not accurate. I just want to lay down a marker that there are disputes about these factual assertions that my learned friend is making. That's all.
Well, no doubt I'll hear from you on that, Mr. Montague-Smith. Now, so what do you want to take me to, Mr. Bowden?
This, if we scroll down here, sir, now this is box file 24, or file number 24. And if you're at the top left, sir, you're looking at, you see the file label there. It's got 24 and followed by 6 zeros, sir, being the very first. So, and this is the general ledger file, sir. So as general ledger, which are documents which don't have an authorized vendor come in, this is where they're put. Okay, sir? And this is where all of the these are the files which were on the accountant's, on the shelf in the accountant's office behind his desk.
Well,
And
sorry to interrupt you.
Yes, sir.
Number 1 under M is journal entries and payment vouchers.
Yeah. It
Is
should
that
be number
what you want
3,
me to look
sir.
at?
3.
You want me 3 photographs of filing system.
Precisely, sir.
Okay.
I apologize.
Yes, I see. Yes, I see
Right.
on the
So,
spines
yep.
of these files. Yes.
That is file number 24, sir. And it's a big file with many volumes.
Yeah.
And if we go down here, sir, if I just ask you to scroll down,
Yeah.
Perhaps we're going on to the next page, the top of the second page, the top of page M88.
Yes, I'm there. Yes.
Yeah. And you see, sir, it ends at 2017-23, right? And the reason why 2017-24 is not there is because that is the file that was provided under discovery, under document production. And that is the file which is now resides at J. Okay. So
Yeah.
what the only purpose of this evidence, sir, is to show that all of the documents we were about to look at, sir, were all found in these volumes, sir, either in the 2016 one or the 2017
Now,
one.
I can imagine, well, that including payments to vendors, which your client handled in the first instance by making a payment out of his own account.
Yes,
Now,
sir.
what about villa expenses and the like?
Yes, sir.
That's all in these files, is it?
Absolutely, sir.
Villa
Yes.
and the daughter's rent and the like. It's all in these files.
Payment in, payment out. Well, my learned friend seems to disagree with that, but to the best of my knowledge, yes, sir. Right. Let's go and have a look at those, sir.
Yes.
If we come back up to reports, which is I, and then we go to I4, sir.
Yes, I4. Yes, I'm there.
Yep.
This is
And
the
then
EMA Saxena report. Yeah.
Precisely, sir. This
Yeah.
is the report. And it's probably just easier to just scroll down. We're going down to internal page 9 on the left-hand side, sir.
Yes, okay.
Which is I139.
139, okay.
Oh, sorry. I129. My apologies.
I129, that's all right.
Yeah,
I129.
terrible memory.
Yes, I'm there. Go on.
Yes. Now, that is table B1 there, sir. Dues payable by the industrial group. Now, this is indeed, sir, this is the 610. Okay.
Yes. Yes.
Well, a slight clarification. It's actually, if we go down, sir, to page I130, you'll see that the tally there is at 753.
Yeah.
Right. But if we come back up to the bottom of page 8, left-hand side bottom,
Yes.
you see the final 2 entries there are rent payment for the chairman's daughter and legal notice payment to Barouge Construction, right?
Yeah.
If you take effectively, if you take those 2 line items out, you're left with 610.
Yes.
That gives you 610,250 dirhams. Right.
Yeah.
So scrolling back to the top, sir, the blue band details of the payments. This is what we're talking about. Okay. So the payments said to be stolen were these. So the chairman's wife asked for 10,000 in cash.
Right, that's not accurate. These are not the payments that were said to be stolen. These are the
Well, I
payments of
understand.
610,000.
I understand.
My
that.
learned friend's correct. These were said to be an attempt to steal. The next ones down we'll look at under file D. They're the stolen ones. My learned friend is right. There's only an attempt. That's correct, isn't it, Mr. Montague-Smith? Right. So we get this first one, sir. The amount transfer to chairman's wife in Jeddah, 10,000. Phone bill for the chairman's wife, 1,600. Well, you can see it yourself, sir. The chairman's 3 sons, they get their phone bills paid. These are adults.
Well, sorry to interrupt you
Yes,
again.
sir. Absolutely, sir.
The author of this report has produced this table.
Yes.
Now, is he simply replicating something which is within the papers which he was given?
Yes, he is.
And so what was he given that which enabled him to draw up this table with these descriptions?
Over on the right-hand side, sir, you see A1, 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 A1,
Yes.
A1, A1,
Yes.
A3, and that, sir, is references to the annexures to the report, and each of these payments are referenced by the annexures given to him by the defendant, much of which he obtained directly from those files, file number 24 that we were looking at. And I'll demonstrate exactly that, sir, if we go to the next page.
Yes.
Because here, sir, this is continuing the 610, okay?
Yes.
And over here, sir, we have, if you see that hyperlink, sir, it's called HM28.
Yes, I see that. Yes.
Now, this is the first line, sir, for the transfer to the chairman's personal bank in Germany. And this is just to meet the expenses of the villa. What has got to be said about the chairman's bank account in Germany, sir, is the chairman gets a text message every time the money goes in. So the defendant's evidence will be that he got it. The chairman will ring him up and say, thanks. Thank you very much, my good friend. And this is how it went between them.
This hyperlink, HM28.
I'll invite you to click on it, sir.
Well, is that something that's been added for the purposes of the hearing, or is that something that was always there?
No, it's something that we have added for the purposes of the hearing, sir.
Yes.
Because it's a reference between the documents. So this takes you, sir, back to the M series. So if you click on it.
Do you want me to click on that? All right.
I do.
Yeah. Yes, I see.
And that takes you there, sir, to the M series.
Yes.
And then you can see there. Sorry, I'm just getting another document open myself for the. Right. That then takes you, sir, through to the payment schedule for that one. Okay. And there it is, sir. We see it's right there. That is the accountant, Mr. Jitesh's writing. Okay.
Yes.
Jitesh Raghavanshi, he's giving evidence, sir. Now you see, so that sign, that stamp, sir, when it's fully there, it says booked by.
Yes.
And it has his initial next to it.
Yes.
And then you have the file numbers there, sir, 24. And then you have it's called the machine code for SAP, right?
Yes.
And so that is exactly how, if we go up one page, sir, to M27, right? This is the printout. We're looking at the printout there, sir, from the SAP system.
Yes.
And you'll see the number top left there, 24000735.
Yes.
Right. So this is how everything goes into the system. And this is important, sir, because these weren't like taxi chits or restaurant vouchers that he was cashing in. These were expenses of the company which had already been booked to the company. right? So these were in fact loans to the company. So they weren't employee expenses, as has been suggested. They were proper administrative expenses where he'd made short-term loans to his employer at his employer's behest. So that's how that works there. If we that particular one is a little disjointed, sir, but if we go down, even down one page, sir, we're really looking at the next document, which is, unfortunately, the way that these documents came through from my learned friend, and it was only a few days ago, sir, on the 25th, they came through in a somewhat disordered fashion. And we have sorted that out, and I'll take you to the actual list, sir, shortly. But we've left them in the order that they came in, extremely disordered, unindexed, unnumbered, but we've done our best. So we just go down to that next page, sir, M29, and we see exactly the same thing happening, sir. This is the calculation of the accountants. It's actually for the same journal entry, sir, and he's working it out, and he's got the AED figure there, and he's also got the those are the bank charges, the 100 and the 40, sir. So if we click back on the hyperlink, top left-hand corner in, we'll call it magenta, sir, that takes us back up.
Yes.
And if we just come down, and if we say, here's a good one, sir. If we go to the one for, if we go to the one for 59,000, so that's M37 on the left-hand side, sir.
M37, yes, okay,
Yes.
wait a moment. Yes, I'm there, yes.
And indeed, sir, this is a transfer to the chairman's bank account in Germany. Again, you have that same journal entry there, sir.
This is in 2017.
Exactly, sir.
Yeah.
So here, sir, you see he's paid the chairman's airfare. The chairman, sir, when he wasn't flying his jet, never went any less than the better half of first class.
Yes.
And that, if you're wondering, sir, is the cost of that airfare from Dubai to Germany and back. So, and indeed, sir, so that was a payment into the chairman's bank account, and we have the chairman's bank account, presumably provided by the chairman. It certainly wasn't provided by my client, sir, which is there, which notes the payment in, sir, and it sits right under the stamp of 15,000 euros, which is what he paid. Right. If we come back up, sir, I'll ask you to go back up the page to M37 and click on the hyperlink again to go home, if you like.
Yeah.
And this is the last one we'll look at in this series, but they're all there, sir. So I'm just waiting for mine to come through. And if we go down, sir, it's down 2 from where we were. So it says transfer to trust account Hillebrand and Partners. Now, the Hillebrand is, and there's a glossary a few pages up from where we are, sir, but Hillebrand is the the German manager of the chairman's estate in Germany. And Mr. Landolt, the next one down, sir, he is the bookkeeper in Switzerland. And below that, Sophia Gomez, she's the housekeeper in Switzerland. So if we go, sir, across to, the hyperlink is going to be called M53, sir. We click on that. So that's a 58,000 dirham, 13,500 euro. 17th of July.
Yes. Go on.
There, sir, again, we've got that same journal entry. It looks to be very badly copied, but I'm sure you can accept that. So I'm just waiting for mine to refresh. Right. Now here we have an email printed out from Mr. Jitesh Raghavanshi, sir. And remembering, this is the document, these are in the documents my learned friends provided last week, after many attempts to get it. Here, sir, it says, Dear Jitesh, and it's from Mr. Farhad Barman. Farhad Barman is an accountant employed by the group to look after the affairs of the chairman, and he works in Jeddah, KSA, sir. So, dear Jitesh, kindly reimburse Mr. Abdelazim's, and this is Saudi Arabia British Bank, sir. Again, there was, we'll come to it in the evidence, but there was complaints made subsequently in 2019, actually, sir, that he was running some sort of money laundering arrangement. And with all of these different bank accounts. Well, the reason why he needed a different bank account in every country, sir, was so he could pay his boss's debts in every country. And he says the reason why I had to pay these debts in the manner that I did, because getting money from A to B in this region is extraordinarily difficult. There's always delays, and the Swiss, and particularly I understand the Germans, who are very intolerant of delays, and we'll see that in the cross-examination. I'm going to go to it, sir, where there were threats. If you don't pay this bill, we'll cut off the phone.
Yes, well, that comes through in the witness statements.
Yes.
Now look,
and the evidence backs it up.
I'm just looking at my watch.
Hmm.
We really got substantively underway at about 20
Yep.
past the hour. And so we've had about half an hour of your...
Well, if you're happy with that, sir, I'll finish with but I think there's one document I should take you to, because we've tried to tie it all together. And if you go back up to D, sir.
D, yeah, wait a minute.
And then you come down to D3.
D3.
This is something that I've produced today, effectively, for today.
The aid memoir.
Exactly, sir.
Yes.
Now, so, and I'll get my associate, Miss McLuffy, is terribly clever about these things, to put those hyperlinks in here for you, sir, so that you can, so I-45 will become a click-through link. But this is a copy of that table we've just been looking at, okay?
Mm-hmm.
And now the EMA annexures, we didn't really look at them, sir, but they're the same documents which are attached to that report. So we've been looking at the M series, but there's also the I series, sir, and that is them. Now, over in the journal entries, for these first half dozen, sir, they haven't been provided. Now, that's not entirely neglect. I think number one is perhaps neglect, although the chairman's wife, she didn't require verification, sir. If she wants money, she gets it. The phone bills were generally minor expenses, and so they were aggregated. That's fine. I think so. And the chairman's power bill, well, he's obviously he's obviously authorised that. The legal notice, Mr. Montague Smith's got some questions about that for the defendant, so I'll leave him with that one. But if we come down to 9, sir, left-hand side, we then have the match-up. So you've got I-54 and M45, M28, M30, and on and so on down the line, right? And so whatever Mr. Abdelazim had obtained from the filing system of the accountants in February 2018, matches up to, and we don't know, there's been no explanation of the provenance of the documents that the 72 unindexed, unpaginated lump that came last week, sir, but we do know where they came from. We don't know who harvested them, when they were harvested. Maybe they were harvested by Mr. Taj and have been available since then, or maybe somebody went through last week and got them. We really don't know. But what we do know is that the right documents have turned up. And what we also know, sir, and what I'll be asking Your Honour to conclude at the end of this, sir, is that they always knew. And indeed, sir, you will have read that that was the conclusion of His Highness the Ruler's Courts appointed an expert, and that was the conclusion of the expert, that these people always knew that these sums were owing. And it's an inevitable conclusion, sir, and one that I will be inviting Your Honour to make based upon much better evidence than was available to the expert. And so that really is, sir. The only other thing I'd say about this is that we didn't cover the 1.3 million, but and that's just if you go down to D70, sir. The next page down in that aide memoire.
Yes, yes.
And we've got the same thing, sir. Other than to say, at this point in time, we've got a third reference source, and that is the highly professional auditor's report. And we'll come to that in cross-examination, sir, but the highly professional auditors had no difficulty at all concluding that this was a wide-scale fraud, and embezzlement was the word that they were very keen on using, fond of using, sir. And it is a pity that they didn't look at the unindexed, photocopied upside down, sometimes photocopied back to front annexures. You've got the pictures here, I take it.
Yes, I had. I followed what you've taken me through. I think that's it for your opening. Thank you very much.
Thank you, sir.
Mr. Montague-Smith.
Your Honour, yes. I was proposing actually to take the 20 minutes that we'd agreed would be taken.
Well, don't worry. I can grant extensions if they're reasonably earned, and certainly you're entitled to some extension.
I shall do my best, but I think I just preface what I say by just reminding Your Honour that quite a lot of what my learned friend says is in dispute. He's not very clear where he identifies what is and what isn't in dispute, and I would suggest that he rather spins the evidence somewhat. And so you're going to see things that are different from what you've heard. So, for example, in relation to what he refers to as box 24, he says, well, we've always been calling it box 24. We've been seeking it for a long time. And Your Honour will recall at the PTR, there was an application for, quotes, box 24. And if you actually look at the defendant's evidence, the defendant's saying there's a file called box 24, and that is what I'm seeking. And that was the evidence that was relied on at the PTR. And so what was produced was a response to that request. And Your Honour may recall I said at the hearing, well, we'll have to look at what the volume is before we produce it, because this is very, very late in the day. This isn't the kind of application one makes at a PTR. And so then we looked at that box and we said, well, it's just a single box, we'll produce it. So we produced it. It turns out that the defendant was asking for the wrong thing. The reference to 24 is a reference to the entire general ledger, all of the payment vouchers in the entire system. And every single year, that number starts again at 1. So it's 24,0001 is the first payment on the 1st of January every single year. So in each year, there are 1,500 to 2,000 of these payment vouchers. So if actually what my learned friend was asking for was the entirety of that system, then that would have been tens of thousands of documents. The way that this emerged was because when it was pointed out to the defendants, when those documents were produced, my learned friend came back and he said, well, that can't be right. This has been filleted, he said. You've doctored these documents, you've redacted, you've removed, you've taken out the stuff that's relevant, because none of this is relevant. And we said, well, no, that's not what's happened. You've asked us for box 24. That's what we've produced. And then he said, well, look at all these documents that are attached to the Saxena report. They all start with 24/ and then a number. That's what I'm looking for. So then we said, all right, if that's what you're looking for, we'll give you that. So we went back, found those documents and produced them to him. So it is absolutely not accurate and is not a fair presentation by my learned friend to suggest that he's been repeatedly asking for these documents. The reality is he's never asked for these documents. We've had to divine what the documents are that he's actually looking for and have produced them insofar as we can. Those are the documents in bundle M. Those are the documents which were on the system. We accept that, and that's what's been sought. None of this was sought at document production phase. This has all been asked for effectively in correspondence. Now, so M24, and we will go through those documents, but just to give you a flavour of what we're talking about, and I'll come back to what my opening was, but I think it's important that I just deal with this now. If your honour goes back to the Saxena report, and just to give you an example, if we go back,
I'm still feeling my way through this.
It's bundle I.
It's I, yes. Wait a moment, please.
And it's page 135.
135. So I can, let me see, find. So I want I-135, yes?
Yes, please.
Yeah. Yes, I'm there. Thank you.
Yes. So just to give you a flavour of this, Your Honour will see, if you look, this is a table of the payments which made up, or the justification for the receipt of 1.3 million dirhams.
Yes.
So my learned friend spent quite a lot of time on the 610,000, and we will look at that. But this is what matters, because his case is that when my client claimed these sums in these proceedings and complained to the Dubai prosecutor that these sums had been stolen, my client knew that these sums were had been received. So if we just look down, you'll see there's a list of dates down the left-hand side of the Saxena report. If you go down, you'll see on the 3rd of April. Do you have that? There are 2 dates.
Yes, I see that.
And those payments are treated together, and they add up to 350,000 dirhams. Do you see that, Your Honour?
Yes, I do. Yeah.
And you'll see then, looking across that line, you'll see that reimbursement was on the 22nd of May, and there's a reference there to 350,000, and you'll see the supporting documents are identified as B5.
Yes.
And if you go down to B5, which you'll have to go down to page 193, I'm afraid.
What? 193. Well, I'll do a page find.
Yes, that will help.
Give me the page again. 193.
193. 193.
Thank you. Yes, I'm there. Thank you.
Yeah. So this is the supporting evidence for a payment of 350,000 dirhams to Mr. Abdelazim.
Yes.
It's a single page. You'll see B5 at the top right.
Yeah.
And that's it, because the next page is B6 and the prior page is B4.
Yes.
This is it. This is the evidence.
If I might interrupt there, sir, I hesitate to do so, but my learned friend will know that 350,000 was paid to the company on the request of the chairman for his jet, sir. It all goes back to this jet.
Sorry.
Right. Well, now wait a moment. We're going to have to. We mustn't have these interventions. Each of you will have an opportunity, of course, to make the points such as the ones you're seeking to make now, Mr. Bowden. So carry on, Mr. Montague Smith. So I'm looking at this. I'm looking at this document.
Yes, thank you. Just to be clear, there's no suggestion in the evidence of what Mr. Bowden's just said, and I've never heard that before. So B5, you will see this is the entirety of the documentation that is put forward in support of the justification for this claim of 350,000. This is said to justify Mr. Abdelazim receiving hundreds of thousands of dirhams from his company, the company that he works for. You will see that that is a document which evidences the payment to him.
Yeah.
To him, that's it. That just evidences the payment to him. It doesn't justify that payment, it just shows that he was paid.
Yes. Now, what's the date of this?
The date of this payment was May, sorry, I think it's May, 22nd of May. You'll see in the middle of the page, there's some writing. 200,000 plus 150,000 has been written in, and just below that you can see 21st of May 2017.
Now, in order to trigger the payment from one of the bank accounts of the claimant, there would have had to have been different levels of authorization.
Yes.
As people other than the defendant must have contributed to the chain of events that led to this payment.
Yes. So all we have on
and are you saying,
yeah,
those who contributed to the culmination of this payment were blissfully unaware of what this was all about?
Well, it's hard to know. And what we can say is we're looking at the system and we can see what has been recorded. So we take it that is what was presented and that was what was used to sign off. And that's, as I understand it, my learned friend's case, because he says these were the documents that were put into the system. These were the documents that were presented for the payment. So what you have is a situation where the head of finance is applying for payment to himself and then approving the payment to himself as well. He was the final approval in the chain.
But that had been going on, hang on a minute, that had
Yes.
been going on for some time. The defendant had occupied a very senior position for a number of years. And over those years, he was the final signer offer, if you like, of payments to himself. It was, surely you accept, it was known that he was making payments in some instances in respect to purchases where it is said that the company didn't have in the month in question sufficient funds in its own accounts. And he was also defraying expenditures of the chairman and his family.
Those are two separate things. So as to the chairman and his family, not every expense of the chairman and his family fell within the company's expenditure. And so in relation to those, he was defraying expenses of the chairman and he was receiving a series of payments back from the chairman. But that's quite separate from payments coming out of the bank accounts of the claimant. That's separate, completely separate. Now, as to the rest, the position of the company is that they weren't aware of these practices going on. And you will see, for example, Your Honour, 175,000 dirhams goes out of the defendant's account into the claimant's account on day one, and day two at 8 a.m. 175,000 comes back. Now, was the claimant aware of that?
Well,
his position is no.
Well, can you explain this to me? What is it then that explains the fact that the accusations of dishonest self-payments was abandoned?
Yes.
What led your client to abandon the initially pleaded claims of dishonest receipt?
Well, in terms of actually what led my client to do that, it was the advice that it was receiving from accountants and lawyers. As to what exactly caused those lawyers to change their advice, I cannot tell you because we haven't got evidence from them. But what we can tell you is that there is more evidence attached to the Saxena report than was attached, than can be found in the claimant's accounting systems. And in particular, there are bank statements coming from the defendant which identify these payments going out. Now, we will go through that. We will go through that in the course of the evidence, and you will see how unsatisfactory the state of that evidence actually is. Now, I don't know.
But the defendant was never asked to produce his bank statements.
Well, we say he was asked. There's a dispute about
when.
He was asked in the meeting on the 22nd of January. He was asked in the meeting on the 24th of January, and indeed at the end of that second meeting, he said he would produce those documents, not specifically as bank statements, but that he would produce the supporting documentation. But the difficulty in relation to the 610 is that we say he was asked to explain it. He never broke it down. And in fact, what happened was he got upset that he was being quite challenged on this. He said, I've been here for 20 years. You shouldn't be questioning me about this. And he went to ground. That is my client's case. And you'll hear evidence about that. And you'll have to decide who is right and who is wrong about that. But the position that my clients were put in was the most senior financial officer was making a claim for 610,000 in a way which we will see was very late, which was unbroken down and was actually inaccurate as to when these things had been had actually been incurred, and then refused effectively to assist in explaining what it was all about. And that is what Mr. Javira says led to all of this. Had he actually sat down and explained it all properly at the time, then none of this would have happened. Now, the reality of this is that Your Honour has seen this Saxena report before. Your Honour has seen it, but hasn't seen the exhibits.
Well, of course, it was a long time ago when I saw it. It was on the day of the application for
yes,
and it wasn't sufficient.
Correct.
For me to set it aside because my memory is having to be refreshed. I don't have an independent memory of this, but it would seem that one of the main reasons why I did not set aside the default judgment was that there was not before the court documentary justification for, if you like, the headline conclusions in this report.
Yes. Well, that's what we say. That's exactly what we say. So until those documents were provided in the annexures to the Saxena report, which was in October, which came after the hearing.
But those documents were all within your files.
No, they weren't, though. That's the thing. They weren't.
Are you saying none of them were?
No, some of them were. I accept that.
Well, what sort of proportion were?
Well, we'll go through, and I haven't done a calculation, and I hesitate to give you a proportion, but Your Honour has seen, for example, what we had for justification of 350,000, and that all we had was the payment certificates, the identification of the payment to the defendant, not the payments out. Now, but the other point about this is that and this is where it matters, that what was being said was it was all in box file 24. It's not the case that there is simply a filing system with a single lever arch file that has all of these documents in them. They are spread over tens of thousands of documents. Someone has to find all of that. And the reality is that Ernst & Young were appointed to deal with that. Now, the criticism that is made of Ernst & Young's appointment is that they were directed not to speak to Mr. Abdelazim. Now, Your Honour may take a view on that. I'd ask you not to take a view on that until you've heard why that was the position, and no doubt there'll be questions about it. I've heard why there is position, but I'm not going to explain to you. I'm not going to give evidence about it.
Well, your witnesses offer an explanation.
Yes. Well,
they say there was a point when the defendant was, if you like, locked out of the offices, and it was felt that in all the circumstances prevailing at the time, it was the Ernst & Young ought to be instructed not to approach him.
Well, that I think
it's in your
yes.
in your witnesses' statements.
Yes, precisely why you will hear from the witnesses, and it's better that you hear it from them. But ultimately,
they're supposed to have written it in their statements as to why.
Yes. All right. Well,
you see, hanging over all this, Mr. Montague,
yes,
is a dispute as to whether or not you were entitled summarily to dismiss.
Yes.
And under the relevant DIFC law, you are, if it was reasonable to do so.
Yes.
The case you have to meet, really, putting it in far side chat terms, is this. Here is a man who's been employed for 19 years. He's occupied a position of high trust. he has a close relationship with the chairman, and there was a point in 2018 when he was promoted to a position of very close association with the chairman. And when these questions arise, instead of being invited in to a meeting and said, now look, we need justification for this. And what do you say about this? What do you say about that? Where can we find this? Where can we find that? Nothing like that happened.
Well, it did on our case in relation to the 610.
Well, I haven't been able to see that, I'm afraid, from the evidence so far. But of course, we're at an early point of the opening. The fact is, it seems to me that there was a considerable amount of material within your own files and documentation that was available to substantiate a significant proportion of these sums of money.
Well, I'd ask you, Honor, just to reserve judgment on that, because we haven't actually looked through the detail of the files. What I've shown you, Honor, is an example of quite a substantial payment that was made to Mr. El Fadil for 350,000 dirhams, and I can't see how it can be justified to suggest that there was substantial material in my client's files to justify that on the basis of that one document.
Well, it's not only a question of what's available, vouching each line of what makes up a particular payment. It's a question of what a reasonable approach would have been in order to determine the question whether there had been dishonest misappropriations.
Well, I mean, in one sense, Your Honour's right. In one sense, that there will be a question of what reasonably could have been done to identify whether or not there had been theft. However, it is not now said, and I do not say, that the defendant stole this money. So I'm not making a case as to that. I'm not making a case that he was properly dismissed because he stole money. That's not what I'm suggesting.
But at the time he was dismissed, one of the motivations was the conclusion that had been reached was that he had stolen it.
That's correct, but it's not a relevant part of that question today. Why not? Because it's an objective test. It's an objective test, and I make this point in my skeleton argument for the opening. It's an objective test, and there are two parts to it. One is that objectively there are grounds which justify dismissal, and the other is that a reasonable employer would have dismissed. And it's not, the Court of Appeal has made clear, like the unfair dismissal jurisdiction in London, for example. It's not a question of assessing what the employer did. It's a question of identifying the facts as they are now known and asking two questions on the basis of those facts. Was dismissal justified, and would a reasonable employer have dismissed? It's not about the steps that were actually taken. Now, where it then also becomes relevant, obviously, is if Your Honour accepts that there are these tort claims, and it's really there financially that these points make the biggest impact, because the actual question of unfair dismissal or reasonable dismissal or dismissal for cause only goes to two heads of claim. It goes to the end of service gratuity and the payment in lieu.
Yes.
And they're not insignificant claims, and I don't dismiss them, but we're talking around, at their best, 2 million dirhams, but on my case, significantly less. On my case, more like 400,000 dirhams.
Yes.
The biggest financial element of this claim comes in the torts, and the torts are now put in the many, many millions. And I say that those are clearly inflated. Yes. And you look at the authorities on that. But if my learned friend's right, and there's a claim for 20 million dirhams here, or whatever it may be, then the question on that is not, was what my client did reasonable in bringing these claims? That's not the test. It's not the test. It's not the case that every claim that is brought unreasonably is in some way malicious prosecution or
Yes.
it's an abusive process.
Yes.
So that's why I say the test is not, for your honour, on any at any stage of the claim, was what my client did reasonable? The question is, did they know? One of the questions will be, did they actually know? Did they actually know that what they were doing, that these sums had been claimed, that had been claimed were due, but nevertheless they came to the court and told you otherwise. Nevertheless, they went to the prosecutor and told him otherwise. Even that, I say, would not be sufficient to make out the claims that are being advanced. It's not every dishonest claim that is malicious prosecution or abusive process. That is simply not, even if you get so far as to saying English law applies. But certainly the test is not unreasonableness. And what I will endeavour to show is that the defendant presided over a system of recording payments out and justifying and accepting applications for payment, manual applications for payment, which completely failed to comply with the policies that he was bound by. Amongst them, that he was approving payments to himself. And that's the critical thing that my client complains about. And he shouldn't have been. And his response to that is, well, it didn't apply to these sorts of payments. We say, well, of course it did. But he consistently approved payments to himself, and he consistently approved payments, even if they weren't to himself, if they'd been for somebody else, which were not supported by the sufficient documentary material. Now, Your Honour may say, well, there could have been more. We could have found out more in April or years after the event. But ultimately, on the unfair dismissal part of it, what Your Honour's looking about is the process of application that was made, not what came next. Because even if you find that they should have gone to him and asked him for justification, even if you reject the explanation for why they didn't do that, that doesn't actually have an impact on the question of unfair dismissal or dismissal for cause. That's the outline of where I am on that.
Yes.
Your Honour, I've been dealing with what my learned friend suggested. May I just?
No, just carry on. Take your own course, and I've interrupted you quite a bit, which I'll take into account in terms of how long you've got.
Thank you. I wouldn't expect to be very long.
Yep.
Your Honour will have seen the various heads of claims, so I won't go back over them in much detail. But as I say, the question about dismissal for cause affects only two of them directly. That's the payment in lieu of notice and the end of service.
Yes.
Gratuity.
Yes.
And what you're looking for on the dismissal for cause are the sort of core allegations are, firstly, that we did not know that he was in effect lending money to the company, and we say that he did that without approval and without good reason. There's also an issue about the way in which certain expenses were in effect prepaid by paying lump sums to the Zurich lawyers so that they could sit in the accounts and simply have expenses deducted from those accounts. And the effect of that was to circumvent all of the policies for expenses, because then the expenses claims that were being advanced would simply be taken from the cash that were sitting in the accounts. And so there was no process for each of those expenses to be verified in the way that they should have been verified. And then there's this point about submitting.
And you say this was going on in 2017? And
yes.
Now, there have been internal audits and external audits for those, certainly for 2017. I don't recall reading anything to suggest that the internal auditors or the external auditors raised any red flags about what you're now complaining about.
No, but an audit, a general annual audit, wouldn't identify things to that level of detail. Ernst & Young were the auditors. They were the auditors of the company.
Yeah.
And so then they were specifically asked to look at the payment process, and they did raise lots of red flags in relation to the payment process. They said it's not a good system to have lots of manual entries, as you see in the 24 system. They say that actually it's incredibly difficult to trace through payment vouchers to any kind of justification, any kind of invoicing, because of the way that the system was identified.
Well, what about the internal auditors?
We don't have any evidence as to any kind of internal audit that was going on, no.
But there was, well, perhaps I've got.
Oh, I see. Sorry, you mean the internal audit report by Mr. Taj?
Yeah, yes.
Well, that came after.
Well, was there any internal surveillance or supervision by individuals within, if you like, the accounts department in general, as to the processes, and B, as to how those processes were being operated?
But Mr. El Fadil was the senior financial.
You're not answering my question.
I'm sorry.
I asked you whether or not there was, not on an ongoing basis, opportunities taken to internally, by those who are charged with the responsibility for looking at what the processes are and how they are being operated. The evidence shows that different systems were introduced at different stages, and that in 2018 there was a new change for these lists. Well, what drove that? What was the trigger for that, if that wasn't an internal assessment that was made of how this was operating?
Yes, I don't. So you do have evidence for what drove that, and we say that it was driven by deficiencies in the system that have been identified. But there's no suggestion, and I haven't seen any, and I'll be corrected by my solicitors if it's wrong, but I've not seen any suggestion that there was some sort of comprehensive board-directed internal audit of the system at that stage. The reason why, and I apologize for not answering your question, but the reason why I mentioned Mr. El Fadil's role is because, as I'd understood it, he's the most senior finance officer, and therefore the person with the obligation, in effect, to supervise and ensure that the system is operating in a way which is satisfactory. So I wasn't trying to dodge any questions.
No, fair enough.
But so I've not seen, you're on speculating about something I haven't seen any evidence about at all, about there being any kind of comprehensive.
Yes. All right. Well, we'll put that in the margin. I take your point. Now, I'm sorry to raise questions of.
Not at all. It's helpful.
Of well, I'm coming on to technological questions.
Yes.
I've got the computer that's showing the e-bundle, so that I've got two screens, one to look at that and one to look at you gentlemen, is saying that my battery is running low, and yet it seems all to be plugged in. So would you give me just a couple of minutes to see if I can solve that? And then, sorry to interrupt you, Mr.
Not at all. Would you need more than a couple of minutes? Would you?
Well, the computer in question was kindly donated by the DIFC Court, and I wonder, Reem, can you hear me?
Yes, Judge, I can hear you.
Oh, good. Now, there's been a very useful IT guy. I think he's called Adil.
Yes, sir.
Can you just alert Adil to a problem? The power lead seems to be plugged in as required, and yet my battery is running low. Does he have any suggestions as to what we should do about that?
Yes, Judge.
Okay.
I'll just get in touch with Adil, please.
Yeah. Good. Okay, well, carry on, Mr. Montague Smith. I can always switch in on the other computer. I can always switch in to the bundle. I'm sorry to have taken up time.
No, not at all. Not at all. I'll try and run through very quickly. What I was thinking of doing was just reminding Your Honour of the specific contractual obligations that Mr. El Fadil was under.
Yes.
But you've indicated that you've seen and looked at the undertaking, which is
I've
probably
looked at the undertaking, the code of ethics,
the authorization policy.
and the authorization. Yeah, I've looked at all that.
I'm grateful. So there was a contractual obligation on Mr. El Fadil not to approve payments to himself without prior written approval of the chairman. It would have been, because that's the superior individual.
Yes.
And then you understand, as I see it, the scale, the scheme of the undertaking. So I'll leave that.
I think so.
Yeah.
Yeah.
So let me just then deal very briefly with the heads of claim that you've got.
Yes.
So that you've got the notice pay.
Yes.
And that will not be due if the dismissal was fair, if I can put it like that.
That's right. Yeah.
If it was not fair, then it is due, and there's a difference between the parties about how much is due. Is it 1 month? Is it 3 months? We say that's a very straightforward dispute.
Yes.
Because the contract provides for a single month. So that's the point there.
Yes.
On the end of service gratuity.
Yes.
Apart from dismissal, again, if it's fair dismissal, then there's nothing. If it's not, there are two issues.
Yes.
The first is the period for the gratuity, and the second is the rate, because you'll know that it's a calculation based on how long somebody's been working for the company.
Yes.
On the period, the difference is that the defendant claims a gratuity for his time working for a Saudi entity.
Yes.
Which is a different entity within the group.
Yes.
But in fact, his employment started with the claimant in 2013, and indeed, the claimant only existed since 2012.
Yes.
So, and there's another factual point here which you may need to look out for, which is that we say that he was paid his gratuity when he left the Saudi entity. There's a dispute about that, but frankly, we don't really understand the case on how it can be said that his Saudi service should be taken into account. It's a different.
Yes. Yeah.
On the rate, there is also a difference there, and we say the appropriate rate is what's known as the basic wage, which excludes certain allowances. So you have to reduce the rate. And we say that warrants a significant reduction. The difference between the parties then on the gratuity is between my case is 338,000, my learned friend's case is 1,452,000. So it's a fairly significant difference, and it's obviously of importance. But it's somewhat dwarfed now by the tort claims.
Yeah.
Counterclaim 3 is vacation pay. This doesn't depend on termination, and the issue really here is how much pay was rolled over from 1 year. Sorry, how much vacation was rolled over from 1 year to the next.
Yes.
The defendant claims for, again, holiday that he accrued but didn't take in Saudi Arabia. So again, the Saudi issue comes up. But we say 20 days rolled over. That's actually in the contract. And because of the employment started on the 1st of April, when you get to the 1st of April, 20 days rolls over. And then he was dismissed very shortly afterwards, and so not very much had actually accrued in the particular year that he was dismissed, and he'd already taken 10 days of holiday in that year. So we say it's quite a small sum. We say that he's actually been overpaid in relation to that.
Yes.
And then the last two heads of claim are the tort claims, and just dealing very briefly with that. Sorry, the last two heads of claim are firstly the penalty claim and then the tort claims.
Yes.
So on the penalty, Your Honour may have seen that issue that's arisen, and the question is what happens when the new law comes in. And so that was the 28th of August 2019.
Yes.
And we say that the law provides that accrued penalties are not affected by the new law.
Yes.
But we say that penalties don't continue to accrue after the new law comes in. So there's an issue about whether or not the penalty continues to accrue once the new law comes in. And we say that on the face of the law, even it's clear that it didn't. But if you look at the policy was intended to remove what was understood to be an unjust situation. But that's quite a significant difference between the parties.
Yes, I've noticed.
It's about 4 million dirhams on the calculation, at least, depending on where you get to on what was owed and when.
Yeah.
And that's an issue of statutory construction. And if you disagree with me on the statutory construction, you'll need to decide whether further sums were due after payments were made against court orders.
Yes.
So,
Now, could I have a sentence or two? Are you going to go on to the tort claims?
I was just about to deal with the tort.
Yes, okay, please do.
Sentence or two on those. Your Honour's heard now, and that's the first time we've heard it, some sort of justification for the tort claims. We say that Your Honour can't just go to the waterfall provisions and get substantive law. The question is what the waterfall provisions are conflicts of laws, the choice of laws provisions. So they tell you, does DIFC law apply or does some other system of law apply? And you can tell that from those provisions because the provisions actually refer to DIFC law themselves.
Yes, that's number one.
Yeah, correct. So if it's regulatory content, then DIFC law applies.
Yeah.
So what it's not saying is where DIFC law applies, this is where you find it.
No.
It's saying DIFC law applies. So there's no basis for saying, it would be very strange if this court said, well, actually English law applies to this dispute, which is all about bringing proceedings in Dubai, bringing proceedings in the DIFC.
Yes, I follow you.
It's a conflicts of laws, choice of laws, provision. So it's right that in some cases there's suggestion that it's possible to inform the content of DIFC law with those provisions, but there's no actual binding precedent to that effect, and it just can't be right when one looks at the laws, because it would be very strange. For example, one of the provisions is that there's a choice of law, and so the parties can agree. So if you were to interpret that as informing the content of DIFC law, you'd be saying, well, actually the parties can agree what DIFC law is, which would be a very, very strange.
No, I follow the point.
Yeah.
But I gave a judgment in the Court of Appeal on forum non-convenience.
Yes, well, that's different because that's procedure.
Well, that's why I mentioned the matter of procedure to Mr. Bowden.
Yes,
but I'm groping a little in a dusty memory here. But the reason that it was important that it was procedure, and therefore there was room for, if you like, DIFC common law to apply, and within DIFC common law there was the doctrine of forum non-convenience, was because substantive matters where there is a dispute between the parties are governed by the waterfall provisions.
Well, when you say governed,
well, yes. You've got to be able to show in any judicial contest in the DIFC court that the law you're seeking to apply is in accordance with the waterfall provisions. Not talking about the content of that law, but, if you like, the body of law. Would you agree with that?
Yes, so it's choice of law provisions. So yes, I accept that. So in other words, you need to be pointed to DIFC law or some other system of law by those provisions. But that's not the way the cases advance. The cases advance on the basis that DIFC law applies and DIFC law's content includes So we're not really at that Article 8 waterfall stage.
No, I follow that. Now,
sorry, go on.
Are you aware of any jurisprudence within the DIFC courts that gives guidance as to when heads of liability can be held to exist outside contract of trusts and restitution, such as the two torts in play here.
No, and it's akin. So there are notable gaps in the law of obligations.
Yeah.
The main gap is the law of defamation, and it's never been suggested that there is a law of defamation in the DIFC, a civil law of defamation.
Yeah.
Why is that? And there's a number of potential reasons, but one of the answers may be that defamation is a crime under UA law. So it's dealt with as a criminal matter.
Yes.
And so it's outside the judicial and legislative competence.
Yes.
Of the DIFC. Now there is, and we've shown this in the written submissions, there is a crime under UA law of lying to a public prosecutor. And so it may be that if this was thought of at all, it was excluded for that reason. More likely, perhaps, is that malicious prosecution, until the recent decisions to which Your Honour referred in the judgment, giving permission to make this claim, until those decisions of the Privy Council and the Crawford Associates, it was understood, there was a House of Lords authority, that malicious prosecution meant criminal prosecution only. So, as at the date when people are looking at this, why would anybody think that they needed to devise a tort of malicious prosecution in the DIFC when the DIFC doesn't have any prosecutions of that sort?
Yes.
But anyway, it's even simpler than that, because if you look at the law, and we'll look at this in due course, if you look at the law of obligations, and if you look at the law of damages and remedies, when each of them says, and the claimant's entitled to damages, it says for breach of the law of obligations. It doesn't say for damages for harm done or torts done or anything like that. It specifically directs, it identifies as the trigger for liability a breach of the law of obligations. So it's not correct to say it's not completely codified. It is a complete code. Now, it may not include everything that one sees in England, but that doesn't mean that we can bring it in. And so actually, there's no room for saying, well, here's another tort which isn't in the law of obligations, but actually there's a remedy for it. You have to find it in the legislation.
Yes, all right. I think fine. Clearly, this is an important part of the case, and the role of concluding submissions is going to have to reflect that.
Yes. I do make one slight complaint, which is that Your Honour ordered my own friend to plead out the legal basis for this. He says, oh, he was waiting to see what I had to say. That's not how claims work.
No, it's not.
So I need to see how that is put and answer it. But my position is.
Well, as I understand, as I understand it, Mr. Bowden's basic point is that within DIFC law, there can be found a tort of abuse of process. That's his basic proposition.
Yes.
And in other words, you can draw threads together from the common law jurisdictions and bind them all into one, into the, well, towards the creation of a new course of action. All right. Now, have we reached the stage now where we're going to hear the first witness?
Can I just say one or two other things on the torts of abuse of process?
Yes.
I'll be maybe 5 minutes, if I may.
Yes. Yes.
I was just going to say, well, look, if I'm wrong, say that Mr. Bowden is correct, and in fact there is this tort. We say there are 4 fundamental problems with the way that claim is advanced, even on the English basis.
Yes.
So looking at the malicious prosecution in Dubai, for example, there was no prosecution. There was a complaint, but that comes before, and that is not sufficient. to give rise to the tort of malicious prosecution on the English.
Yes, I see. Yeah.
And the second problem that he has is that there's a prosecutor in Dubai, and that's not the claimant. The claimant's a complainant.
Yeah.
There are there's authority as to when a complainant can amount to the prosecutor.
Yeah.
It's where they put the prosecutor into the position where the prosecutor can't really make up their own mind. And there's very limited circumstances where that has arisen. One of them was where, for example, a prison officer lied so comprehensively to the prosecutor that the prosecutor authorized the prosecution. But that's not this situation, because the prosecutor in this case looked at the evidence and decided not to prosecute. So there are real fundamental problems with all of that. You will hear about what the motivation was, that there's an overlap in terms of the objects of the two sets of proceedings and the relevance to the two tests, malicious prosecution and abuse of process, because the definitions of malicious and the definitions of abuse lead to very similar conclusions, because what the court is looking for is an illegitimate object for the proceedings, not something for which those sorts of proceedings are intended. So it's not enough to show that a party is going about proceedings in a way which is to be criticised.
No.
So it's not the case that simply, and I don't accept that it is.
There has to be an illegal collateral motive.
Correct. Yeah, exactly. And one that cannot be a motive or an object which is to be obtained through the normal results of litigation. So if your motive is to ruin somebody, that's an unpleasant thing. On one view, one might say, well, it's not what litigation's for. But actually, if the object is to ruin them through the normal incidents of litigation, then the authorities say that is not sufficient.
All right.
And what I say is that we don't really have a proper and coherent explanation for what the purpose is said to be. When Your Honour gave permission, the purpose was said to be that the chairman took the resignation as a personal insult, but that was never pleaded. That's not the pleading. What's said is that the motive was intimidating, prolonging legal proceedings, harming the defendant's reputation, lowering his standard and credibility, and so on. And it's all really a bit all over the place when it comes to that. But Your Honour has seen and heard enough from me about why these proceedings were brought.
Yes, I think can we you've submitted at some length in your written submissions on the questions of the torts, and I think I'm going to ask you now to finish.
Yes,
I'm going to treat you as having completed your opening, if I may. Now,
can I just help you with two aspects on the evidence that you're going to hear, simply because of the witnesses and the timing of their.
Yes, I'm going to come on to the practicalities of the evidence.
In fact, my learned friend asked me to talk to you about one aspect of them, which was Mr. Beckley. The other aspect is Mr. Anjum, who gave the document production statement. That's shortest because I put him in the list because I'd assumed he was going to be cross-examined. My learned friend said that he probably doesn't want to cross-examine him, but he wants to think about it and he'll tell me over lunch. Okay. So we'll know how many witnesses we have then. In relation to Mr. Beckley, you'll see he's 8 hours behind because he's in Ontario. So we plugged him in at 4:15 on day 2.
Okay.
Which is 8:15 a.m. at his time.
Okay.
So he sort of needs to go there unless we're going to get him out of bed very, very early. And everyone's happy with that if Your Honour's happy with that.
Yes.
The difficulty is that Mr. Jabir is probably going to come first. And if he starts on time at 2 o'clock of day 2, he may not be finished, I'm told, by my learned friend, by the time we get to Mr. Beckley. And so we may need to...
Or we may have to intervene in his evidence and continue it after Mr. Beckley.
Yes, and that's fine. What my learned friend said, though, is that he may need more time with Mr. Beckley than you get running up to 6 o'clock. And Your Honour may think that it's not very satisfactory for Mr. Beckley and Mr. Jabir are both to be broken and continued the following day. So it may be that we might need to ask Your Honour just to sit a little bit later on. Just to finish. And that's all I was going to say.
All right. Now,
hello, sir. Sir Richard, can I interrupt for 2 minutes, please?
Yes,
This is
okay.
Adil from IT.
Oh, I should
Adil.
have got a message to you.
Yeah,
I've
you have
solved the
my WhatsApp
problem.
number as
I've
well.
solved the problem about the power for the second computer. And
So
I'm
it's
very
solved.
sorry that I didn't get that through to you, but I've been involved in listening very, very carefully to the opening statements of
Yeah, I
both
also
sides.
don't feel to right to interrupt. I also joined at the same time, but I didn't interrupt because you were having a conversation.
Well, there you
Sorry
go.
to interrupt now. Okay. Thank you.
It's all solved. It's all solved. Thank you very much for
Thank
your for coming along and raising it. But it's all done.
Thanks, sir. Thank you.
Okay, thank you. Now, has any protocol been agreed as to the giving of this evidence? For instance, if oaths are going to be taken, is there going to be anyone present with the witness who can offer the Quran if the witness wants to swear a religious oath, or on the Bible, or what? And what documents are going to be available to the witness? Is it all going to be soft documents, or is it going to be a mix, or all going to be hard documents? And who's going to be allowed to be in the room at the time that the witness is giving his evidence? And any thought been given to these matters?
Yes, sir, there has. We've spoken with Mr. David True at some length. There's not a protocol in place as yet, but we've both agreed so that the witnesses will be on their own, in a room on their own. And indeed, Mr. El Fadil, he is in a room on his own right now. He's linked in to this, and he's on case lines, sir, and he's familiar with it. There is I understand, a Quran here, sir, and his oath can be taken on the Quran. So that's...
Well, it's normal that the Quran is in the hands of the witness.
Yes.
When he makes his oath. Perhaps he has a Quran.
We do.
Where is he, at home or what?
No, we are at the offices of my instructing solicitors, sir, and so is he, and he's in a separate room.
Right.
We're at Bindahi Advocates, sir.
Do you have is there within the precincts of your offices a copy of the Quran?
Yes, I understand there is, sir. It might take I meant to get it, I forgot, sorry, but it's yeah, we've got one.
All right.
And so he'd be on his own, sir. I think he's got a few personal notations that he's made on a couple of documents, but we're on the system, sir.
All right. Right. Well, then he's the first witness, isn't he?
Yes, sir. But I think it would be helpful, sir, if I was given 5 minutes, because a lot of what my learned friend has said to you, sir, is just plain wrong, and I can prove it in 5 minutes by reference to the documents I put before you this morning, in particular the aid memoir. It's perfectly set up for this purpose, sir.
Well, wait a moment.
Yeah.
As you know, there's a verbatim transcript which is going to be produced, and that's of great assistance when someone wants to go back on a point and develop an answer to it. I don't want to hear from you now on that matter, but you'll have to remind me. But when reminded, of course, I'll give you an opportunity to make the point that you would have wanted to make. Now, should we have a short break of 5 minutes or so before we start the evidence? Is that long enough? Does any?
Well, I'm afraid, have used up the entirety of the morning in Dubai. We're now at 1 o'clock in Dubai, which was going to be lunch in Dubai. Now, I'm happy to.
Are we going to have lunch now?
Well, we'd operated the hearing schedule on Dubai time.
Yes.
We're very much in your hands as to whether we take a lunch at a later time.
Well,
might be more sensible to start the witness now and have a late lunch in Dubai, but I'm in your hands.
Well, what do you say, Mr. Bowden?
I think that's an excellent suggestion. I always agree with my learned friend, sir.
It's what is it now? Is it
5
Is
to
it
1.
1 o'clock or 2 o'clock?
5 to 1, sir.
It's
12
5 to 1.
Yeah.
Yeah, well, I think if we had, let's say if we had 45 minutes of the witness, and then we'd break for, say, half an hour for lunch. What was the time allowed for lunch on your recent time?
We allowed an hour between from now till.
Okay, well, we might pare that down to 45 minutes. Very well. Well, then let's move on then to the evidence of the defendant. Mr. Bowden, over to you.
Yes, Mr. Abdelazim, can you hear us?
Yes, good morning, everyone. I can hear you.
And can you switch on your camera, please?
Okay.
Well, I can see the witness, so presumably his camera's on.
Brilliant. And do you have a Quran placed before you, Mr. Abdelazim?
I don't have it in the room, but I can look at one in the office. Yeah, now they brought me one.
One is just arrived.
No, I can't see the witness at the moment.
Your camera, Mr. Abdelazim, it needs to be on.
Yes. Yes, thank you.
Thank you, sir.
And I think Reem will administer the oath. Is that correct?
Well, I'll administer the oath.
Sure.
Now, do you swear on the holy book of the Quran that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do, sir.
Thank you very much. He's in your hands now, Mr. Bowden.
Thank you, sir. Now, Mr. Abdelazim, can I take you to document E1 of the case lines bundle? Do you see that?
Yes, I can see that.
Okay. And is that headed 7th witness statement of Abdelazim El Shikh El Fadil Hamid for trial?
Yes, correct.
Okay. And did you make that witness statement?
I did make that witness statement.
And can I take you, and you might have to, do you understand how, use the find tab if you would be so kind? And go to type in find page E55.
Yes, I'm there.
And there's an electronic signature there, correct?
Correct.
And is that made
That's
or caused to be made by you?
Correct.
And you've said there that you believe the facts in this witness statement are true.
I believe so.
Is that correct? And
Correct.
I'll take you again. Can you go now to document E2? And do you see it said there, the 8th witness statement of Abdelazim?
Yeah, reply at trial, Sunday, 4 July 2021.
Is that a witness statement made by you?
Yes.
And indeed, using the find page function, can you go to page E82? Sorry.
Yes, I can see there is an annexure.
Sorry, E81, my apologies.
Sure. Yes, we can see my signature there.
Okay. And dated the 4th of July. And again, you've said that you believe the facts stated in this witness statement are true.
Yeah, I do.
Is that correct?
Correct.
And can we come down, I'll just take you to that annexure. Is that a document made by you?
Yes.
Did you type it?
Yes, I typed it.
Thank you. Can you stay where you are and answer any questions?
Okay.
Thank you. Good afternoon, I think it is, Mr. Is it Mr. Abdelazim or Mr. El Fadil that you'd prefer?
My name is Abdelazim. El Fadil is my grandfather. It's a family name. And used also to go to the fourth grandfather in Sudan to be Hamid.
I see. So
yeah.
what would you prefer me to refer to you? I don't want to cause you any offence. Is it Mr. Abdelazim, Mr. Hamid?
No, it's, I think the judge already decided his honor to be El Fadil, Mr. El Fadil.
Mr. El Fadil.
Well, that's very kind of you. Thank you very much.
Thank you. Thank you, sir.
Thank you. Now, Your Honour, just to pause here for 1 second, yes. My solicitors are going to try to help those people who are following on case lines.
Yes.
By directing them to the page. It may speed things up.
Okay, good.
If you're on case lines, can I ask then Mr. True to do that as we go, and then we'll see how we go. Before we look at any documents, though, can I just try and clear up a couple of things, please, Mr. El Fadil? Yeah. And start at the beginning of your employment, if I may. So you started your employment with the group as a whole in 1999, didn't you?
Yes, I started in 1st November 1999.
And you were working at that stage for the Banawi Industrial Trading Group Limited, is that right?
Yes, it is right.
And that's a different company from the claimant, isn't it?
I cannot say that because, as I said in my witness statement, that as a legal entity, yes, it is different.
Right.
It is not the same. However, I said in my witness statement the reason why I have some comments on that.
I see. All right, but it's a different legal entity.
Yes.
And it's a Saudi company based in Jeddah, isn't it?
Yes, it is.
All right. And you joined that as an accountant back in 1999.
Yeah.
And then you continued working for that company until 2013, didn't you?
For that company, I can say till my date of termination, because those company is still under my responsibility and is still under my duties.
Yes, but you resigned, didn't you, in 2013? I
did resign. That's something we'll take it later. That's a letter presented.
I'm asking you now. You did resign in 2013, didn't you?
No, I didn't resign. That's a letter. I signed a letter presented by the HR that they told me this is part of the procedure they are following.
I see. So if you go to bundle F, page 23.
Yes, I'm there.
And so you sent a letter, didn't you, saying, please accept my resignation from the position in Jeddah Corporate Office effective from 31st of March 2013.
Yes, this letter was presented to me by the director of HR. And it is, they said exactly what I said just now. They told me this part of the procedure. It's not a resignation from my employment. The resignation, they told me, from your position in the corporate office, which is in Jeddah.
You understand the difference between two legal entities, don't you?
To me, it's one legal entity. It's one employer for me.
But you just told me that it was a different legal entity.
I'm saying in the way of registrations, yes, there are two different entities.
Yeah, and you understand what a contract is, don't you?
Yes, I understand.
And your original employment contract was with the Saudi entity, wasn't it?
Yes, it is.
And it wasn't with the claimant entity, was it?
That's what I'm saying. I have another thing to say.
No. Can I just ask you to answer the question, though?
No, I understand what you're heading.
Yeah,
I'm saying I receive a letter for transfer. Okay, there is a lot of things here. One is that I already joined the company here and get my visa that in 2012. Okay, and I'm saying there is no change in my responsibilities at all.
Right.
It's just changing the base of my base will be Dubai instead of Saudi Arabia in Jeddah, and that will impact only one thing, that whenever I'm in a country different than my base, I will get reimbursed for my expenses. That's the only difference to me.
You are not saying, are you, that when you were employed in Saudi Arabia, you were employed by the claimant?
Yes, it is the same as employed in Saudi Arabia, already being employed in Dubai, in the claimant.
No.
I moved to the claimant because at the end, the claimant is on the Saudi 100%.
Well, let's take it in stages then. In 1999, you were not employed by the claimant, were you?
99, no.
No. So,
Yeah.
so in 2000, you weren't employed by the claimant, were you?
In 2000?
Yeah.
No.
No. So in 2011, you weren't employed by the claimant, were you?
No.
No. So you say, when do you say your employment with the claimant started?
It started already in 1999 because the company itself is coming from, they just moved the corporate office. They moved some of the employees. So for me, it's a transfer. It's not a termination of my employment in Saudi Arabia. And that the financial statement of the company, to get the history, is saying that there is a common interest between the owner of the claimant and the owner of the Saudi entity are the same, and so that the standard allowing that to be historically the financial statement of the claimant for last 3 years before its incorporation. Again, it can assume that those financial statements and can assume that activity.
Well,
So
I'm sorry to interrupt you.
yeah,
I'm going to intervene here because we're really at the moment on a pure question of law. And at the moment, it seems to me clear that there were two separate legal entities. At one stage, you had an employment with one of them. At another stage, you had an employment with the current claimant. Now, it may be that there are certain principles in employment law that say in these circumstances, you should be treated as having been continuously employed from one to another, and no distinction should be taken on a legal basis. But as a matter of contract, it seems to me clear that you ceased to be employed by the Saudi company and you became employed by the claimant. And whether there are particular rules that deem you to have been continuously employed by one overall organization is, in a sense, it's a matter in the margin, and we'll see what the significance of that is. So I think, Mr. Montague,
thank you, sir.
I think you can move on to another topic.
So when you resigned, or when you signed, before you signed a contract with the DIFC entity, can we put it like that? You agree that that's a fair characterization?
Yeah.
That was in March 2013, yes?
Yes.
All right. Now, before you did that, once you sent that resignation letter that we looked at, the Saudi entity paid you some money, didn't they, in respect of your end of service gratuity?
Again, as I will follow again the direction for His Excellency, that is still something also under debate. I can say I received some in advance to those amounts of the end of service for the Saudi company.
Well, do you say you were entitled to that money when you received it?
Yes, I do.
All
because it's something normal, and that's something. If I've been paid, I should receive that money.
Yes. So you were entitled to it, and it was an end of service gratuity, wasn't it?
It is not the full calculation. If you're assuming that it is for my, if you separated the periods, that's not the full amount either. And second, also, they did not normally. They have to take from the employee, that's part of the procedure of the company, that this is your end of service, that's all, and you have to get his approval and signature.
All right.
And that's never happened.
We'll talk
I
about
just said.
We'll talk about the calculation in a minute.
Yeah.
But the money that you received was money that you say you were entitled to in respect of your end of service gratuity, yes?
Yes.
All right. Now, you don't, companies don't pay employees end of service gratuities along the way, do they?
They do. Our company, they do.
But how would you calculate it? Because you don't know the final salary.
They make it like exactly what you are saying there, Mr. Thomas.
Well,
that's, let me explain. I'm saying I agree with you. They didn't know the salary at that time. That's why they make it as an advance. They calculate up to this date. However, legally it's not acceptable anyway that this is the case.
Well, so how would they know that it was even going to be due at the end? Because if, for example, you're dismissed for cause, you wouldn't be entitled to it.
Correct. Yes.
So then they'd have to pay the money back.
No, it is not, because if it's been released, that means at that time it is good to get paid. And fortunately, I refer to a case of the employee of the company, exactly what you are saying. With the case of Mr. Fadil, exactly telling the same thing. That was being paid in between, and the court finally, they disapproved that payment. That's why I'm saying.
In fact, what was prepared was a complete calculation of your entitlement, wasn't it? Can we look at F25, please? We may have to rotate it.
Yes.
And do you see there, Banawi Industrial Group End of Service Award?
Yeah.
And your name at the top left? Yes?
Yeah.
Yeah. And then do you see it gives your nationality and then reason for leaving, resignation, yes?
Yes.
And date joined November the 1st, I think that's 1999. Date service ended 31st of March 2013, yes?
Yes.
And then it sets out a calculation of what you were due as a result of that, yes?
There is some calculation, but I'm saying it's not correct, as I said.
I see. So your position is that this document is not correct. It's
I was not being involved in that document.
So you say you never received that document?
Never received this document.
You've never seen it before? I've
seen it within this procedure.
I see. So I'm going to suggest that this document was provided to you at the time, and as I understood it, you had signed it. Is that right?
There is no, my signature is not here. I never signed this document. I never signed that I received this money. That as being full payment of my end of service, gratuity payment.
All right. Now, the schedule identifies a sum due of 437,570 Real. Do you see that under the heading total award? Yes.
It is saying, repeat again what you are saying, 99 or what?
Do you see in the middle of the page total award 400? I've got it 437, 570. Yes.
Yeah, it's not clear, but I saw a better document. Yeah.
Now this is a standard format for end of service gratuities for the group, isn't it?
This is standard format for the approval. However, there is other formats also to be attached to that, which is the undertaking and final release and other things.
But this is the standard.
This is part. Yeah, this is standard for calculation.
And is it right that you just insert the salary into this and the date, the start and end dates, and it calculates the sum automatically?
Correct. Yes.
Yeah. So, and do you accept that your monthly salary, your monthly basic salary at the time was 30,800 Saudi riyal?
No, it is 44, as you can see on the top.
No, that's your monthly lump sum. But do you accept that the monthly basic salary, do you see under that, is 30,800? Yes.
Yes, this is not correct, and it's not legal in Saudi Arabia.
It's not legal.
Yeah,
I
by
see.
the law, have to be calculated in full.
I see. So you think that it was undercalculated because it reduced by the basic, by the allowances?
Correct. Yeah.
Right. But either way, that would be a sum that was owed to you by the Saudi company, right?
Yeah, assuming that this is the end of service, yes.
All right. Bear with me. If you go to F26, I'm afraid we're going to have to rotate out of this again.
F26.
It's the following page.
Yeah, it give me the end. Yeah, we can see something like a calculator.
Recognize this at all?
This is a calculator?
This is an end of service reward calculator issued by the Saudi government.
Yes, correct.
All right. And do you see what happens? You put the relevant inputs in, the salary, the duration of service, number of days, and so on, and then it calculates the amount of end of service gratuity.
Yeah, but the salary is not correct.
I see. So
if the calculator, they have to put the full salary. If there is something legal, it will be deducted automatic. Or there will be a place where you can put how much is the basic, how much is the full salary. That's why it is the calculator is right, but the entry is not correct.
So you're saying that the amount that was calculated for you was too low, and that in fact you were owed more money at that date?
Yeah, assuming that that's my end of service at that date, end of employment. Yeah.
All right. And I'm going to suggest that, in fact, you were well aware of this calculation at the time, and you agreed to receive that sum in compensation for your end of service gratuity with the Saudi entity.
No, as I said, it is via an advance payment, which is happening to some of the other employees with a long service in Saudi Arabia. And still, some of them is still working with the group, with the entity in Saudi Arabia, who has been receiving part at a point of time.
Let me ask you about your vacation. It's correct, isn't it, that when you left the Saudi entity, you didn't in fact have any vacation left, did you?
It's not correct.
Well, if we look at the document at F25, which is back at the end of service award.
Yeah.
Do you see on the left-hand column, vacation balance days, 0? Do you see that?
Yes, but I didn't agree with that.
I see. So you say that is wrong as well?
Yeah.
I would suggest that that is accurate, and that at the date of your termination or your resignation in Saudi Arabia, you didn't have any vacation left, did you?
No, I have vacations as well. And I also put in my witness statement that has been transferred again to Dubai to be taken in Dubai.
All right. Now,
otherwise not being paid.
Now, you say that you know of another employee who had their vacation rolled over when they moved companies from the Saudi entity to the DIFC entity. I think that's what you say in your witness statement. And
Yes.
you refer to a Mr. Desai, I think is how you pronounce his name. And we can find a reference to that document, the relevant document is at bundle H, page 1, the very first page of that document.
Yes, correct.
And so this is the individual, isn't it, who you are referring to in your statement when you're talking about another employee who had their vacation rolled over when they moved from the Saudi entity to the DIFC entity, yes?
Yes, correct.
All right. And your point, I think, is that if you look in the middle of the page, on the left-hand side of the column, it says annual vacation. You see that?
Yeah, I can see that.
And then if you go across, it says current status 30 days. And then under the remarks, it says vacation balance as at 30th of November 2012 will be carried forward to enable Pasha to take vacations without interruption. So that your point is that he was given that, he was allowed to keep his vacation from the Saudi entity and bring it across with him to the DIFC entity. So the point that I'm going to make is that if your vacation balance was rolled over in that way, you got one of those forms, didn't you? You would have
yes, it should be, but I didn't get it. Even Mr. Basha, I didn't get that. For me, it is not. I didn't receive such document.
Thank you. All right. All right.
The only document I received in this regard is a transfer letter.
Thank you. All right. Well, not quite, because you also signed a new contract, didn't you?
Yeah, but even the new contract I signed, it is prior my resignation as well. My resignation is on 14th of April, and my contract is 27th of March. Yes.
Mm-hmm. So it's backdated.
Yeah.
What's your point?
My point is that this is this document was presented to me, after I signed the contract, and after I moved.
So are you telling me that when you signed the contract, you thought you were working for two different companies at the same time?
No, I understand it's the same company, and now just moving the head office to Dubai.
You thought it was the same company?
Yeah.
So you read that and you thought that. So let's go to it. G1. I know Your Honour's asked me to move on, but I'm just trying to understand what the witness's understanding was at the time, and see whether or not what he's saying actually really makes sense. If we go to G1, that's your contract, yes? You just told me that you thought you were signing a contract with the same entity.
Yeah.
But do you see there on G1, you're signing a contract with the Industrial Group Limited, a company established in the DIFC?
But if just to start with that, if you look at the letterhead of the company, it is BIG. It's not TIG.
Yes, but BIG is what it was the brand for the whole group, wasn't it?
Banawi, yeah. That is where I was being employed.
Yeah, but that's just simply the brand for the whole group. You knew from this contract that you were signing a contract with a DIFC entity, didn't you? Or are you telling us that you didn't understand that?
I understand that. As I said, they told me this is part of the procedure. Nobody told me your rights of employment in Saudi Arabia will be jeopardized.
I see. So your complaint really is that you weren't advised properly about the effect it would have on your employment rights in Saudi Arabia. Is that a fair summary?
Correct. Yes, I can accept.
Thank you. All right. When you joined the DIFC entity in 2013, you then signed this employment contract, and later you signed the company's code of ethics, yes?
Yes.
And you later signed an authorization limits policy, didn't you?
Yeah, that keeps changing, yes.
And it kept changing, and I think the version that we've got.
The first one I didn't sign. I signed the latest one.
So you signed the one in November 2014. Is that what you mean?
17.
17. So you didn't sign up, but you were aware that you had to comply with the policies of the company, yes?
Sure. Yeah.
So you knew about the authorization limits policy that was brought in 2014, yes?
I do. Yes.
Right. And then I think the one you mentioned later in 2017 was actually the undertaking. Do you remember that?
No, there is another policy of authorization already uploaded
I see.
by the claimant. Yeah, and that's the one I endorsed. I signed it.
I see. All right. And so that's updated, but then you also did sign the undertaking, yes?
Yes, I do.
All right. Now, I don't want to trespass into the legal arguments about the meaning of those documents, but it is important about what you thought your obligations were in relation to some of these things. Now, and you have given evidence about what you thought did and didn't apply when certain payments were being sought. So I'm just going to ask you briefly to look at a few of these passages and just explore a little bit about what you thought were your obligations. Can we start then with the Code of Ethics? If we go to G8, so it's the same bundle as the contract in G8.
Yeah.
All right, and if you look on, that's where it starts. And if we go down to G10, do you see there paragraph 8, avoiding conflicts of interest?
I'm sorry, I only have under G, I have from 1 to 6.
Ah, so you will only therefore have the contract.
I have from 1 to 6. The last one is the claimant's policy on authorization limits, 2017, and then it
I'm
goes.
so sorry. I'm referring to the page numbers. I do apologize.
Oh, I see. You're not the numbers in there. All right.
I'm so sorry.
That's probably my fault.
No. I'm sure it's me. It's the second document, document 2.
The document 2. Fair enough.
So I was going to ask you to turn down to page 10 of that of the bundle.
Yeah. Okay. I'm there. Anyway.
And the Code of Ethics. So it's paragraph 8. And it mentions the fact that avoiding conflicts of interest is one of the fundamental principles of ethical behavior. Confidence in the group can only exist if directors and employees are known to be acting in the best interest of the group rather than pursuing their own interests and the interests of third parties. And you should avoid any conflicts of interest between themselves and the group, and explains when those might arise. Now, you say in your statement, we're obviously in this case dealing with a number of different payments, some of which were payments that you received, and some of them are payments that you claimed. Yes. And as I understand your position from your statement, you say that this conflict of interest provision did not apply in relation to any of the applications or claims that you made for payment to yourself. Is that right?
Yeah. Right. Correct.
All right. Because you say that you didn't have an interest in the payments that you made on behalf of the chairman. Is that why?
Yes, because I did not party to those dealing with either the chairman or the claimant, the TIG, with the third party.
I see. And you took that view. Sorry.
Yeah, that totally different transactions. I just paid on their behalf based on the instructions, and I received my money.
I see.
Or I didn't receive it.
Or you didn't receive it. All right.
Yeah.
But but even when you were applying to be repaid that money, you took the view that there was no scope for a conflict of interest to arise.
Yes, correct.
And you took that view throughout your employment, did you, with the claimant?
No, it's totally different because there is other times, other incidents also I can go to. If there is any kind of conflict of interest or any expenses that was being incurred by me directly, I took the approval of the chairman of my senior. That's why I fully comply with that. Most of the payment, thousands of payment that I paid on behalf of myself, okay, and I got the approval of the chairman.
All right, but I'm talking about the bit where you go to reclaim those payments, and then you need to put in an application to seek the repayment. Yes, or you take steps to authorize the payment on the bank mandate, for example. At that stage, you took the position throughout. There's no conflict of interest possible here.
No, the way you said it, Mr. Tom, I'm sorry, or the way I understood it, that across my employment, this is what I am applying. I'm saying no. So whenever there is any conflict of interest, I do get the approval of my boss.
I see. Yes, but
yeah,
what I'm talking about, the payments that were made to you by the company. amounting, for example, to 1.3 million.
Yeah, let us be specific about the 1.3 million, yes.
Well, I can show you your evidence if you like, if you need me to remind you of it. Would you like me to do that?
No, I'm just trying to be specific that you are saying all the payments. I'm saying there is many payments other than the 1.3 or 1.4 or the 6 that I receive, and I do get the approval if there is any conflict of interest. But for the 1.3, yes, some of them, that's the position I took, and some of them, where there is a conflict of interest, part of the 1.3, I took the approval of the chairman.
So you accepting that there was a conflict of interest in relation to some of these payments, or you don't accept that?
No, I'm saying that if there is part of the 1.3, for example, one payment I paid to a third party, and for that I get the approval of the chairman. Part of the 1.3 itself.
Well, let's just have a quick look at your evidence here, if we can.
Yeah.
It's in bundle E, behind tab 2, sorry, page 61. This is Mr. El Fadil's 8th witness statement.
Did you say the 8th one?
It's the 8th one.
Yeah, okay.
Unfortunately, the header for the 8th witness statement, if you're looking at it separately from the system, is also marked 7th witness statement. So you will recognize it because in lots of places there's reference to Mr. Jabira's witness statement saying KJ number 16, for example. But you should see it dated 4th of July, if that helps.
Yes, I've got it anyway. I've got it.
So paragraph 15, you say, as you say, Mr. Jabira does not refer to any findings or evidence which prove that I committed any of the breaches listed. As stated above.
I'm sorry, Mr. Tom, again, because first you led me to E21.
E61. E61.
Oh, sorry. Yeah.
So you say that you're rejecting Mr. Jabira's suggestion.
What is that?
Paragraph 15. You can go back to Mr. Jabira if you like.
Yeah, 15, yeah.
All right. You say Mr. Jabira is saying that you put yourself in a position of conflict of interest.
Yeah.
By making these payments or approving these payments to yourself, and you reject that. And in the middle of that paragraph, you say, as stated above, the chairman's arrangement for payment of expenses does not fall under the authorization policy, nor does it fall within the scope of the claimant's code of ethics.
Yeah.
So your position was that none of the payments which you were making and receiving in this regard, that is all of these payments that we're talking about, fell within the scope of the claimant's code of ethics. Is that right? Is that your evidence?
No, as I said again, that we need to go in further detail to the payments. As I said, most of the payment, they didn't fall exactly as I said in my witness statement. However, I'm just highlighting there is some payments where there is conflict of interest. Okay, I got the approval of the chairman. At the end, none of them have any conflict of interest, or if there is any conflict of interest, it was being highlighted.
But that's not what you say in your statement, because what you're saying in your statement is it doesn't fall within the claimant's code of ethics at all.
Yeah. So I'm saying it is. I mean, it is. I'm not saying it is not being within. I'm saying it is not being. It does not create any part of conflict of interest.
Well, reading this, what I'd understood and what I'd suggest is the position that you took was that you didn't think that you needed to comply with the code of ethics.
No, I'm saying I'm complying with the code of ethics, and I am complying with the code of ethics, and I'm already complied. Is 100% with Part 8, which is the conflict of interest.
All right, but so you will at least accept, will you, that when you are seeking a payment back for money that you have previously paid out, there is a potential conflict of interest there, isn't there?
I don't agree with that because there is no, because I'm not party. Conflict of interest have its own definition. It's not about just receiving the money. It is about how that transaction was being created.
Yes.
Do I involve in anything? I'm being paid on the instruction of the chairman as well. So this is his instructions, just to make all these payments and get my money back.
Well, you've got to split it into two, don't you? There's the risk of a conflict of interest that arises, and then there's the practical steps you take to manage that conflict of interest afterwards. So I'm just dealing with the first stage. You keep telling me, oh, and by the way, I did it, but I'm just trying to understand your attitude towards whether or not there was a conflict of interest that arose at all when you were receiving these payments. I'd read your evidence as saying that there was not. I thought that you were now accepting that there was, but now you're telling me that there wasn't. So can you give us a clear explanation? Do you accept that when you applied and when you sought permission and when you approved payments to yourself, there was a clear potential for conflict of interest there?
Okay, let me explain that. Any payment, to me, it should have a conflict of interest. However, the payments which I paid, especially the 1.3 or part of the most of the 1.3, does not apply to a conflict of interest. I did not see any conflict of interest in that.
All right. Well, I think
I'm saying, sir.
Can you please give me an example of a situation where you seek a payment to yourself by way of reimbursement, where there is a potential conflict of interest, and an example of where you seek reimbursement for a payment you've made when there is no conflict of interest? That would be helpful for me.
Thank you, sir. Yes, I will do that. Okay. If I can go to the payment instruction report.
Can I just ask, are you referring to notes?
No, I just want to share His Excellency one of the examples where there is maybe a conflict of interest.
Well, is it in the documents, in the bundle documents?
Yeah, yes.
Can you take us to it? Do you know the reference?
I have the reference, sir. It's I221.
I221. Okay.
Yes, sir.
Yes.
Yeah. Actually, sir, these are the expenses, the summary of expenses, and I attach also the documents that approving that those payments. And I took the approval of the chairman because those expenses, I have the contract. I made the office expenses paid from myself. I get an hotel and I paid that hotel. I went outside and take some food that to be reimbursed by the company. I rent a car in Jeddah. I took the transportation in Dubai. All these, I have created those transactions with the third party. This here, there could be a sort of conflict of interest. Maybe we don't know to whom I have maybe I have a relation with the hotel, maybe I have a relation with the taxi. That's why if you see down there under them in the handwriting, there is an Arabic word. It's yu'tamad, means approved, and here the signature of the chairman.
I see. And so where you were seeking repayment of a payment you had made either to a third-party supplier or to defray the chairman's expenditures, you took the view there was no conflict of interest because you were not someone who had the benefit of the money. You were discharging an obligation of the company to a creditor. And so far as the chairman's expenses were concerned, you were paying the chairman's expenses and you weren't paying yourself.
Correct, sir.
I got that right?
Right, sir.
Yes, thank you. Oh, Mr. You're muted.
I'm sorry, I shall make a
That's all
donation
right.
to charity.
You're back now.
So just to follow up on that question, in the circumstances where you thought there wasn't a conflict of interest, you thought that there was no conflict at the stage where you were requesting reimbursement as well.
Correct. Yes.
I see. And that was something that you made clear to the rest of your team, or at least it was an attitude that was shared by the rest of your finance team, wasn't it?
No, that's because they knew that I'm handling the things for the chairman, especially things for the chairman, and they had that at all the time. I'm making such kind of payment. Sometimes they're getting reimbursed from the chairman, sometimes getting from the company.
Yes, but
and for them, so that they have to make sure that those payment it is being paid to a third party. The engagement is not. I'm not involved in that engagement with that, and that they have to make sure that I made that payment on behalf of the claimant or the chairman.
I see.
Then yes, they can be.
What I'm going to suggest is that whenever you are claiming reimbursement, regardless of what that reimbursement is for, so whether it's for expenses that you've incurred or for expenses that you've paid off on behalf of somebody else, there is scope for a conflict simply in the application for reimbursement, in that you want to be paid and it's in your interest to be paid, but it's not in the interest of the company clearly to pay you. So there is a conflict between if you're sitting and presiding over that situation, isn't there?
Maybe I cannot get you right. I can understand what you are aiming to say.
So whenever you are applying for repayment, whatever for, there is a conflict if you are approving that payment, isn't there?
I think I said it enough that there is two things, that if I was not party of the original agreement, that there is no conflict of interest.
All right. Let me ask you about the process of getting approvals then.
Well, just I think it's now 1:45.
Thank you.
And I think we thought we'd have 45 minutes of the evidence and then we would break for lunch.
Thank you.
Now, Mr. El Fadil, we're going to take a break now for lunch.
Sure. Yeah.
And I have to give you a direction which I give to every witness. And that is this, that until your evidence is absolutely over, you've faced all the questions that Mr. Montague Smith wants to ask you, and the questions that you might get from your counsel and from me. Until that point, you must not talk to anybody about this case. In particular, you mustn't talk to your lawyers. You must have a lonely life. You can, of course, talk about matters that don't relate to this case. It would be safer if you simply had no conversation with your lawyers at all on anything, just to, so that no question of any doubt can arise. So you are in purdah until you've finished your evidence. Do you understand?
Sure, yes, I understand.
Thank you very much. So we will resume at 1:30. Thank you very much.
Thank you, sir.